and get started. We have enough for a quorum, so we can begin this. I'm sure you heard Kim stuck at traffic, and we're trying to find out where Gerald is, and we'll go ahead and proceed and let them join us when they get here. Okay, at this time, we need to approve the minutes from our November 12th, 2014 meeting. I think everyone's had an opportunity to hopefully review that. You should have received those from Amy via email. So any comments, thoughts, changes, whatever. Good evening, sir.
Good evening. Sorry I'm late.
Oh, you're fine.
I did not notice anything, so I'll go ahead and move that we approve the minutes as submitted.
Okay, thank you, Bill. We have a motion by Bill to approve. Jason has a second. All in favor, show of hands, please. Okay, passes unanimously to approve the minutes as written. Okay. Next thing on the agenda is for us to review Articles 9 and 10 of the Civil Service. I'll let our counsel, Mr. Keith, take care of that for us.
All right. We had a couple of catch-up items on 9 and 10, and I neglected to catch up on one of them in the report that I sent out. So if you'll recall, we had a question about, I'm looking at the memo dated December 8th, doing chronological order. And we got all confused about the discharge employee after probation period. I included a copy of the civil service rules for you, and there was an issue about the term of office in the charter, and a question about layoff. Use in the charter is inappropriate since people employed in the classified service are employees of the city. No one seemed to know how that was in there unless it was a period relating to police officers. So we recommend that the phrase officer or be deleted in sections 9, 12, and 10.07. Yes, ma'am.
Okay. Okay. All right. We have a motion by Nancy to approve as stated. You have a second? Ellen, we got a second? All right, all in favor, show of hands, please.
I don't know what we're voting on.
Um,
Sorry.
Deleting the reference, the phrase
This minute.
officer or, that was in sections 9, 12, and 10.07.
Okay.
Okay. All right. One more time. Get a vote on that? Okay, passes unanimously. All right.
This is the second.
Kim, sorry you're stuck in traffic. Please get something to eat. We got sandwiches, so forth,
Thank you.
and we'll be happy to kind of move and go at the same time. And Pete made homemade pie, so be sure to get some of Pete's pie.
That's not pizza pie.
Now, and still looking at my memo of December 8th, we had an issue on 10.06 because there were some language layoff. It was confusing about if there was an appeal, who to go to, it said in reference to the officer. And if I'll just follow along with that memo. The section is titled layoff. That section speaks in terms of the position being abolished or vacated, resulting in a dismissal without cause. So if they abolish a position and there's no lower position that's available, then ends up in a dismissal without cause. Section 72 of the Civil Service Rules addresses demotion as a result of an abolishment of a position in the classified service and dismissal without cause if there's no lower position available. However, Section 53, discharge employee after probation period of the Civil Service Rules provides an appeal for an employee removed, suspended, laid off, or reduced in grade by the city manager or head of department. The reference to the duty of the officer discharging such employee in section 53 is really a reference to the city manager or the department head. Section 10.06 could be amended to change duty of the officer to duty of the city manager or department head, as the case may be. The reference to laid off could be changed to dismissal without cause due to abolishment or vacation of position if you find it necessary. The reference to removed in section 53 in charter section 10.06 is a reference to dismissal. Unfortunately, the terms discharge, remove, discharge, and dismissal are used interchangeably in the civil service rules, depending on the context and what rule you're looking at. So, at the very least, we recommend that you change officer discharging, the reference to duty of the officer discharging such employee to the city manager or department head, or the department head, as the case may be.
Okay, so we have the charge, whether we want to change that to the duty of the city manager or department head as a recommendation. Any discussion on that? Okay, I think those were the things that we were concerned with, and Pete did a great job of researching that and getting that back to us, so we appreciate that. Anyone want to make a motion to accept that change or that verbiage?
And that would be change the duty of the officer to duty of the city manager or department head, comma, as the case may be.
I make the motion.
Okay.
Second.
Second by Nancy. Any further discussion? Okay, show of hands in favor. Passes unanimously. All right. Thank you.
Let's see. All right. Now, should also have a memo dated December 15th, and that was to address an item. We were talking about the duties and purpose of the City Planning Commission, and there was some language in there that actually talked about the City Council. It was in an inappropriate place, and Nancy was nice enough to mention that I had not included that in my last report, so I apologize. So I'm sorry if you got late memo, but nonetheless you got it. So we had postponed taking action on 9.07B, which was the powers of the Planning Commission, which contains some awkward language. But if you go to page 2 of my memo, what I've done is taken the original text of section 9.07B and marked that up with recommended changes. And I know Bill's always interested in fewest words possible, so I know he'll be excited about eliminating subparts 1 and 2. It doesn't really change the substance of it, but it clearly indicates that the Plan Commission serves as an advisory board to the City Council, provides reports and recommends the City Council approval of and disapproval of proposed changes to the zoning ordinance and map, makes recommendations on the adoption and amendments to the comprehensive plan, and pursuant to city ordinances, exercise control over plating and subdivision of land within the city and in the ETJ. Extraterritorial jurisdiction is a defined area based on the size of the city as certain. I don't think we have ETJ left around the city of Richardson, but in any event, and it performs such other duties. So that clearly sets out what the powers are, and the subdivision regulations in Chapter 21 of the Code of Ordinances set forth the planning requirements and duties of the Planning Commission. So, unless you have any questions, we'd recommend that we change 907B to read as marked in our memo of December 15th.
Okay, has everyone had a chance to review that and read that?
On 907C, membership and terms, you put in the note to change to clarify residency. As I recall, we pulled the residency out of all the individual committees and left it up in the front of the section.
Right.
So they all have the same.
Right, right. And then when we finish everything, we're gonna go back through and make sure we didn't miss anything, and so, but we had only postponed, we dealt with everything else except B, and so I wanted to get us caught back up, so I can update the running changes that we have.
Peter, is there anything in here that we're actually taking away from the planning commission?
No, sir.
Had to ask.
No, sir.
Okay, any questions for Pete or any additional comments regarding these changes?
Yeah, down at the bottom of page 2 of his memo, there's a paragraph that says B, and then it says powers. And the underlying section says, City Plan Commission shall be responsible to and act as an advisory board to the city council. Now, you said advisory board, but you didn't mean that for purposes of the Texas Open Meetings Act, right?
No, I didn't.
Would that
It
cause
is-
any
you know,
confusion with
under
anybody?
the Open Meetings Act, the animal is what the animal is.
Sure.
So, no, but that was to clarify that it serves as an advisory board to the city council, but then it talks about it exercises control over planning and makes recommendations on zoning. But under Texas Attorney General opinions and case law, planning and zoning commission, or in our case, city plan commission, is a quasi-judicial body.
No, I believe that it is. I'm just concerned if we say advisory board, someone's going to read it literally, as opposed to if we just said the city plan commission shall be responsible to and advise the city council, as opposed to the phrase advisory board, which is kind of.
I'm not married to any language.
Okay. I mean, does that make sense anyway? Advisory board is something that's talked about in the Open Meetings Act, and it's not subject to the Open Meetings Act. But as Pete says, certain boards aren't advisory boards, no matter what they say. And I just don't want someone to read this and think that we are calling an advisory board when it's not.
That's a good point. So what's your suggestion, change?
That we convert it into a verb. The city plan commission shall be responsible to and advise the city council. Unless someone can think of a smoother way to say it.
I like that.
Yep.
The only other way to do it is add another verb, provide advice or something like that, but I think
Let's
advise
do
is.
that. Sell advice? You sell advice?
No.
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 All right. Amy, did you understand? Okay. We've got, is that a motion, Bill, that you have now?
No, it was just discussion point, but if you like, I'll move that we approve.
But hold on, because, do you want us first, Pete, to approve the first B, the 9.07B, and then approve Bill's B?
No, you can make a motion to.
All the
approve
907?
907B.
With
Okay.
Bill's.
With
With Bill's?
Yes.
Okay.
So we have a motion. Pending.
Whose motion is it?
Well, would you rephrase your motion, or give us a motion that
I
you
would
would like?
like to move that we approve the updated 907 as presented by Pete with the change I indicated, and honestly, I don't know what paragraph that is.
It's 907B.
907B, is it?
Powers.
907B under powers.
Where we change the phrase, we remove the phrase advisory board and replace it with advices or advice, whatever I say.
Okay, Amy's captured that, so we're good. Do we have a second to accept that motion as Bill presented? Jason seconds. Any further discussion? Show of hands in favor, please. Okay, passes unanimously. All right. Pete, that brings us to tonight's topics of Article 5, is that correct?
Yes, sir. Articles 5 and 14.
Okay, Articles 5 and 14.
Mr. Chairman, I also provided a copy of Chapter 277, I believe, of Work Procurement Code. Hopefully I made it into your packet.
Yes, yes, you did.
And, because these are elections that are outside of the election code, and so Chapter 277 provides some general requirements that apply to those types of elections. So I wanted to give you the background information. Because referendum and initiative and recall, as I've indicated in those comments to you, is simply a creature of the charter.
Go ahead, sir. Go ahead, John.
I want to ask about the Section 5.02B. Petition shall be signed by qualified voters equal to the number of at least 10% of the total entire number of qualified voters on the date of the last regular municipal election. And there are times when a municipal election is combined with other, in other words, it's really what you're talking about is the registered voters in Richardson. So that's really it. Whether it's a general election, when if it happens to fall in November or whatever. So it's just those registered voters.
By the way, I didn't make any substantive changes,
Right.
so I didn't change any percentages on initiative or referendum. So, as I've indicated, trying to clean up the language and make it easier. But we probably ought to need to go through section by section.
Yeah, I agree. I just jumped the gun there with it, sorry.
I have a question on A. If I read this correctly, it says that I believe that a separate petition is required for the mayor and each city council member.
Yes,
That
ma'am.
being said, then do we need the and/or qualifiers, Pete? Can it
Where-
just say the mayor or council member, the mayor or council member whose removal is sought? Because you can't, if I read it right, you can't do it on the same petition.
Well, if you look at the, whatever you'd like to do, but the last sentence indicates a separate petition shall be required for the mayor and each council member.
Right, so I'm wondering if we can just simplify and say the mayor or city council member
Okay.
instead of the and/or, because you can't do them both in the same one, right?
Or a council member.
Right.
Maybe we go back to 501 and get 501 taken care of before we go on to 502.
Okay.
Uh,
All right, is everyone good with 501? Okay.
I have a question. On the wording, Pete, it says something about a signer has to attest before a body that every person who signed that page is who they say they are. And the signer has to be a signatory on that page. Is that right? So you have to have as many people attesting if you have pages turned in?
No, because there can be, a petition taker can do a whole bunch of pages to sign each one.
And only have to attest one.
But he's not signing as a petition signer, he's signing as a.
There's a separate line at the top saying, I, so-and-so, did this page, and I got these signatures.
Okay. Just as a matter of practicality, do they check licenses, IDs, or anything like
No,
that?
absolutely not.
What they're really attesting to is that that person signed it in their presence.
A witness.
It's basically
A witness.
witnessing. And then when it's turned in, the city secretary looks at the information to determine if they are a qualified voter and so forth. But We're back on 501.
Yeah.
I'm determined to get 501 done.
I move so we approve as with your changes.
Okay. All right, we have a motion by, a second by Jason. All in favor to approve 501? Okay, passes unanimously.
Okay.
5.02.
Right.
Poor peas.
And we have on 5.02,
Okay.
we're looking at A, that currently recall of the mayor or a council member. That is our current recommendation. Are there any other recommendations under A?
Other than that's done 3 times in that paragraph.
Right.
I have a question about the complete statement of the grounds for which the removal is sought. In your note, Pete, we have the ability to set forth what those grounds can be. Is that what I understand that to say?
Yes, ma'am. Some charters say, as I indicated in the comments, incompetence,
Misconduct,
Misconduct.
malfeasance.
It's up to you. It might be a good idea because they might say, because he voted against a zoning case. You know, I mean, it's up to you. I mean, it doesn't say it right now, but if you look at other charters, they typically say misconduct, violation of the charter. So that's up to you.
But even if you use the word misconduct, that's not defined by law, that's a personal.
That's true.
The vote could have, it might be my opinion that vote against was misconduct. It's very subjective.
You want to say something? Yes, and by listing things, are you restricting reasons?
Yes.
Leave it
Yeah.
broader.
Question.
Yeah, I would say leave it as is. But I do have another, this is real small, non-substantive comment. The last sentence of that paragraph A, it looks like at the end of that line, the word "the" is omitted by mistake. A separate petition shall be required. It says for mayor, maybe it should be the mayor.
For the mayor.
Good catch.
That's my contribution for
Gerald.
Okay. Any other thoughts or comments on 502A? Okay, let's move to B then.
I do have a question. Where is that data available? The number of qualified voters?
Amy will answer that question.
That's from the county, from each county, that's where 2 counties.
So if someone were to file a petition, how do they know how many signatures that 10% would be?
They would probably check with me.
Okay.
Big long day.
That would be a combination, of course, with
Right.
Collin County, Dallas County.
Yes.
all that.
In 2013, there were 43,000 plus change in Dallas County and 16,000 plus change in Collin County for a total of about 59,700, which is, that's a lot of registered voters.
Gerald?
Is this the section, Mr. Murphy, where maybe you were getting at, there should be a minimum number, because in some elections, there may be an unusually high number if a lot of things are on the ballot versus a normal election, and then does the comment P8 on the side, does that address that, and is it worth discussing?
The reason I raised the point is that it's hard to get some people excited about some of the types of elections that there are. Municipal elections have always drawn a low number of voter turnout. School bond elections, if they're held on the same date that the municipal election was, there'll be a very high number of voters that show up. Or if it happens to be held at the same time as the general election on November second Tuesday in November, then there is a huge number that will be the hurdle that folks will have to overcome. So I guess what we're saying is that the voter registration list stays pretty much the same, no matter who or how many votes were cast. So that eliminates the problem that I've heard several people say you don't want to, base it on who voted, you want to base it on who's eligible to vote, which is about 5,000 to 6,000 people basically.
Okay, thank you, I agree with that. But does the comment specifying, asking if we want to specify a minimum number, notwithstanding the percentage, does that go towards B, Mr. Smith?
In lots of charters, whether it's recall or initiative or referendum, some of the charters have a minimum number in case they have such a low turnout from the last election. But they didn't want to have such a low threshold, so few people be able to initiate the process. And that's simply
But Pete, it's not based upon who voted, it's based upon who's registered to vote. So basically, you don't have to say a minimum number if it's not based upon who shows up at the polls.
If
Is
you
that
look,
right? Am I
if you
right,
look
Matt?
at other charters, the ones that specify the minimum are the ones that say based on votes cast.
Cast,
The
yeah.
ones that specify based on registered voters, they won't say that because they don't need to.
This is the percentage.
So I don't think we need.
So I don't think we need to.
No,
I don't think we either, I don't think we need to.
Well, we're a home rule city, we're gonna have more than, hopefully.
5,000.
Yeah. Although we could go smaller than that and not lose our status, I think. If I may, Mr. Chairman, if I may say, I looked about 9 cities in the area, and I noticed that Plano had 30, this is for recall, Plano required the petition to be 30%, Addison, 25% of the qualified voters. Farmers Branch was 15% of the qualified voters. Mesquite was 40%, but I'm not sure I read that right, because they also wanted people that voted for the person being recalled to admit they voted for him. So I'm not sure I read that right.
Wow.
Dallas says 15% of qualified voters, and Irving says 10% of qualified voters. So we're on the low end of this thing. And I don't know if that makes any difference to anybody. I don't know, frankly, Pete, I have no idea how many recall elections we've had in the North Texas area in the last 20 years.
none of our cities.
I've had one. But it's been
You had one in Farmers Branch?
I had one in Carrollton,
Carrollton?
mid-90s, so it's been a while.
Well, it's been a while.
There may have been one in Rowlett or about that kind of thing.
The reason I bring this up is on the recent petition we had in 2012, I think, to amend the charter, which, by the way, is a whole different ballgame from here. That's covered by state law, I believe. It was 5%. And we found that, in my experience, the 5% number was reached only because someone paid petition takers to go stand in front of the library and collect names. It wasn't going to happen if someone did not pay. I mean, this is literally democracy for pay. And that's because it was at 5%, it was such a low threshold, someone could afford to do that. Now, again, we can't change that because that's state law, I believe, the local government code mandates at 5%. But it does make me worry about, is 10% the right number, or 15, or why do these other cities generally have higher percentages? And what's the thought about it?
That's initiative referendum that you're talking about.
Also recall.
Also recall as well?
Well,
And they're trying not to have a low threshold
Right, I understand that.
to trigger election.
When we had the petition going around for direct
Actually,
election.
but that's not any one of these. That's charter amendment, which is a whole separate code. No, it's not initiative. It's not any of those. Charter amendments are actually dictated by the state and the local government code, right? I believe that's true in the local government code. I just was reading it. And that's where the 5% comes in.
So,
Because if you look on our charter, I think our charter says you can amend our charter by petition process and go look at the state code for the details. So I'm using that as an example of how easy it is to 5% if you have money, while admitting that it isn't directly one of these three.
Well, why don't we do this? What was the approximate number of the qualified voters last city election?
Was it not 59,000?
Because you have to have a percentage of the mayor.
Okay.
Or for the,
You're talking about the number of votes?
No,
I'm talking about
qualified voters.
qualified voters.
She was answering number of votes. That's
Yeah.
14,000 was the votes cast in the mayor.
But you had just said 59.7 of registered voters in 2013, thereabouts, was the number the bill had, 59.7.
59.7.
So
The registered
10%
voters.
is,
there's almost 6,000.
It's almost, yeah, that's more than 5 or 6,000. That'd be harder to buy.
Yeah, right. And the petition for the charter change only needed 5%, so they were able to get the 3,000 or so fairly easily once the program kicked in.
No idea.
But 10%, 15%, 20%. I'm just curious if anyone has any idea why these other cities have higher thresholds.
the reason is, they don't want to trigger a recall election unless they have a large majority of the people that are interested in doing it.
You're right.
I mean.
One observation on Addison, you're talking about a much smaller population.
Mhm.
You're talking about probably in the 14,000,
Oh,
so,
yes, very definitely.
so they may increase. Was there 20?
There's
25.
25. So
25.
That's a good point.
You said Mesquite was 40%?
Yeah, but it was the funny one about talking about how a lot of them had to admit that they voted for the person they tried to recall. So I wanted to go back and reread it, honestly. It was kind of weird. The other ones were the 10 to 25% range.
So, but in keeping with the charge of the council, it's not broke, don't need to fix it.
Yeah.
But if you want to recommend a substantive change, whether it's up or down on that threshold, you certainly welcome to do so. So I think what your question, Bill, is do we want to change that percentage?
I will also note that of the cities that do it based on votes cast, they were generally 25 to 30% of the votes cast, which is probably often a lower number than even 10% of the registered voters. So, 10%, half the cities did votes cast, and if we had 14,000 votes cast in the mayor's race, what's 30% of that? Four or 500. Well, obviously 10% of the registered voters is much larger than that. So, Pete, you're right. If it's not broke, don't fix it. So I guess I just want to bring this up as, this is something we have control over. We don't have control over the 5%. We do have control over this, and it's going to show up again in the referendum and initiative things as well. If we're happy with 10, that's fine.
10 sort of smacks you as reasonable. Up to 40, that's maybe unreasonable. And so there's you're trying to not make it an impossible
Right.
goal.
Right.
And discourage the effort if there's real reason to do it.
Right.
But going from 10 to 15%, is that substantive enough to make a difference? Another 300 votes?
So,
Well, that's in Richardson, that's going from 6,000 to 9,000.
Yeah.
That's a lot of
yeah,
signatures.
that's a,
6,000 is enough of a barrier to entry to
Exactly, so
discourage
going another
shenanigans.
5% may not make,
9,000 is more people that have voted on almost every election, municipal election, except for that.
that's true.
so that's where the 10% may be just right.
Yeah, I'm all right with that.
It's a great point.
All right, good discussion. All right, we'll go to C.
Do we need to make a motion?
No, I think aren't we doing 502 all the way through and then coming back to approve as stated? Okay.
That's pretty much parallel to the state language,
Yes.
isn't it?
And is there anywhere in here where it says each petition has to say the same thing? We had some issues with last time, people write, I think that, I'm right here, where they actually
John,
wrote.
don't confuse that charter amendment.
Oh, I'm
stuff.
sorry, okay.
Because that,
I was just thinking about the gathering of signatures process.
it says a petition, but it can be in multiple copies.
Okay.
So,
The way it worked, John, is that the petition takers each had a copy of the thing and showed it to the signatory, and then allegedly at the end, they stapled it to the petition that they gave to Amy.
Yeah.
Hopefully it was all the same one.
But it wasn't on the same page.
It was not on the same page.
That was the problem.
That's exactly right.
Okay. Any comments on C? Okay, let's go to D.
I have a comment on D.
Okay, Kim.
I'm wondering if, on, 5, 6, 7, 8, the 8th line, we use the term officer. Is that one of those places where we need to replace it with administrative official, like we have in other places? If so, I'll make that recommendation.
That's actually a reference to a notary public,
That's,
isn't it?
yeah,
Officer competent.
that's a reference, is officer account administrator oath, which is a notary public. There are other people who are authorized under state law to notarize who are not notary public.
Okay.
But again, is the verbiage that she's recommending, does it have to be the word officer or official?
Are you saying official or officer? Okay.
Instead of officer, what do
I
you,
see-
Kim, what
I
was
see.
yours?
Well, in other places where we had officer, we changed it to administrative
Okay.
official.
See,
No, that's a good point.
I don't think we need administrative, just official
Just
should be
official,
sufficient.
okay.
I
just
think.
official?
So you want to change officer to official?
Right.
To an official competent to administer oaths.
So that would include a private notary public, correct?
Yes, well, hope so, but that's how it's done.
In that same section, the last sentence, no signature shall remain effective or be counted, which was placed upon it more than 30 days. How do you know?
Well, because it'll have the date they signed.
They
But
sign.
but we need to talk about that because if you look at C, C seems to suggest that as soon as they start circulating, it starts the clock and they have 30 days. So that language in D, that last sentence, last D, needs to be consistent with C. Because as you see in my comments, I was indicating it's not really clear. Is it 30 days from once they tell the city secretary, I'm circulating a petition? Or is the signature good for 30 days prior to the date of filing the petition? Because it may or may not.
So in timing,
Or does that work? Now I'm questioning my own math.
But let me ask you a question. Oftentimes, the pages shown on the petition will have a date at the top. Are you saying that as part of the petition process, the date has to also be when the person signed? Okay.
The petition will have place for them to sign, their date of birth, voter registration number, the date they
The
signed.
date they signed, that's right.
That's
That is on
required.
there.
Unless that person attests at the bottom that everybody above signed on that date. It's supposed to be put their date they signed on.
That's right, it is that.
So if the 30 days begins, let me ask you to check my math. So if the 30 days begin, once they begin circulating the petition, would that last sentence in D be correct, that no signature petition shall be effective if it was placed on in more than 30 days before filing?
To me, it says the same thing.
Okay.
Clock
All right.
starts ticking when they tell the city secretary, and they got 30 days to turn it in.
And I think it speaks to the notice provision. The notice still has to be given to the city secretary before you start.
That's kind of the key date.
And that last sentence in D is saying that signatures before, a signature that was more than 45 days old would not be counted.
And that makes it clear when reading C and D together.
Right.
Okay. I'll make sure.
Amy, so in that process, if you were going through his petition and you see that some are dated further out than 30 days, you would go through and have to mark through them, and then come back and get total count again to say whether it's a valid petition. All righty, we're down to E, yes, sir.
That's just me, I don't like from, I like after.
Yeah, that's clear.
Amy, you've been through some of this, and some of it, except what we got. 10 days enough?
Maybe too short. We're ready by the signature.
Ray, talk about F.
No, he's
We're
talking
still
about.
on E.
10 days. Within 10 days.
Within 10
First
days.
sentence.
City secretary.
Is that enough time?
Where is that standard?
Well, it's 10 business days. That's how it's
Well-
interpreted, right?
No, unless you say business days, it's calendar days.
Tactically, is it enough?
I have not had to verify a petition of that size. That happened right before I got here, and the girls in the office had already done it. But I know they scrambled, but that was a lot larger number.
But it could continue to be a lot larger numbers.
Yeah,
Is there a
6,000.
standard piece?
It varies. Some don't even specify the time, which is not a good idea. I think some are 15 days. Bill, you looked at several. What did you find? I didn't
Honestly,
bring my-
10 days is what sticks in mind, but I thought it was 10 business days.
It's not.
So Amy's working all weekend,
That's generally what happens.
And then Amy gets a spa day on the 11th day.
Yeah, I think 10 is normal, for better or for worse.
And so I wasn't trying to make any substantive change, so.
Yeah, 10 is what I'm familiar with.
I think that's fine. I mean, for a candidate's petition, which is a lot less,
Yes.
we have 5 days, but that's to check, verify several different things, not just the petition. So,
My guess is if we get to a recall, it's all hands on deck.
Yeah, and that's what it would be.
I think
Yeah.
5 days is fine.
You would.
Fine.
Good point.
We'll have 30 days to start that.
That's true.
All righty, well, let's go to F then.
I struck that language because once something's filed with this, then it becomes a public record, so you shouldn't give them back their petition. We'll keep it. So really only change there wasn't any substantive change, it was just better language, I thought.
When the word insufficient is used in the first line, is that solely in reference to the number of qualified voters who signed?
Yes?
It wasn't a main reference to the content of the petition.
Unless there's something not on the line, like the birth date isn't there, or the signature.
Well, no,
You're
I
talking
meant,
about that.
So,
Well, let me interject this, because it'll apply to the city secretary's examination of a recall petition or initiative or referendum. While Texas Election Code 277 and charters say you gotta put date, signature, and date of birth and all that, and registration number. If the city secretary is she's performing a ministerial function, verifying that there's sufficient signatures on it. And so if she has enough information in there to verify that they're a qualified voter, the fact that they forgot their date of birth doesn't matter. And that's what the case law.
no, that's not what I was worried about. I was worried about, it doesn't say the number of people signing are insufficient. It says the petition itself is insufficient.
but if
That's
the
opening-
numbers are insufficient, that wouldn't be the petition.
That's what we mean, is the
Okay.
numbers, right?
But-
But it's not what we say.
I
You're
guess
talking
I'm,
about the cause.
I'm saying that if there isn't a number, that it's insufficient no matter what.
No, What I mean is that someone could construe this to mean that there's something defective in the petition itself.
Instead
Not
of not having enough numbers.
Signatures, right.
Got it.
And like, why didn't we say, I mean, this is one of those situations where, you know, most people, I assume, would read it that way, but I don't know. But what we mean, clearly, is that if by the city's secretary's certificate, the number of petition
Well, it may-
finders is shown to be insufficient.
Well, having said that, it also would include, it doesn't, well, we don't require statement of grounds. So that would, maybe they don't have the right name in there. They thought it was John Murphy, but they had Pete Smith in there. Well, that guy, the one with the gray hair just got married, that's the one I want, not Pete Smith. So maybe the name is incorrect.
You think it means
To
that
me, it
also?
does not mean numbers.
Oh,
Because
okay.
a petition could be insufficient because it's not notarized.
That's right.
Okay, so that actually goes to the next question on F, which is, if we're gonna be amending this petition, are we amending the content of it or adding more signatures?
It could be that.
Could be either or.
Could be, that she looks at it and says, you don't have enough signatures.
I think for content, it has to be a new petition, because the last sentence talks about
True.
grounds. But that one concerns me a little bit right there anyway, because, you know, we haven't, I mean, the problem is that we try to define it, we almost make it even more definable. We start talking about words like misconduct and malfeasance.
But leaving those out is ever so misleading. If there's certain things that should be considered as being reasonable recall, then by not addressing that, are you not making it where you could go back, as I think Pete pointed out, if somebody voted against a zoning change, and therefore we're going to recall them?
That's part of the concern I have about that last phrase in the sentence, a new petition may be filed based upon new and different grounds, but not upon the same grounds.
Yeah.
I mean, first of all, who determines what the grounds are?
Right.
And what if there's only just a small difference? Say it is a zoning change or something like that, and you say, well, incompetence. Well, you don't get enough signatures, or there's some other kind of defect in there. So it allows you to go back to the well and say, you know, instead of incompetence, malfeasance.
And that's.
I mean, you can go to the well over and over again, potentially.
Yes.
Does that
and
make sense?
For any number of reasons, and that's one of the things that, is there anybody on the front end of this that gets to say, I'm sorry, but that's not a good enough reason for a recall? Is there any provision?
It's not up to us, or the city council, to determine whether or not it's an adequate reason for recall. I mean, unless you specify grounds, and then within those three categories, those typical three categories, you know, they say for misconduct because they voted on a matter when they shouldn't have voted. Well, and maybe that's not a correct statement of the law. Maybe they didn't vote, or they didn't have a conflict, and could have voted, whatever it might be. Then the whole point of this, we don't want to disenfranchise the folks in submitting and asserting it, you know. He believes the moon is made of cheese. Really? Hopefully don't get enough people sign that petition.
But if you do,
You know, got the right number of signatures on there?
To address your point, Jason, on that last thing, I would avoid grounds altogether, as we deleted earlier. And I would say rather that if, after one chance at amending the petition, they still fail somehow, then there should be a time lag of, say, 30, 60, 90 days before such a recall against the same person can be submitted again. Because that's what we're trying to do. We're trying to avoid recalls over and over and over on the same person.
And I think I addressed that in.
Alternate
Yeah.
language
It's
under
in that
504.
letter.
You had proposed some wording on that?
Yes,
On
ma'am.
the 8th and the 15th was good.
What did you say?
5.04, at the bottom of that page we're just on.
The alternate language, yeah.
And
Either
that-
one of those is,
Bill, you're a visionary.
He's reading ahead.
either one of those is, you'll find that it's common to find the charter
Okay, are we good with F, or are we wanting to,
Well, I don't have a problem with the use of the word grounds, because grounds does relate back to,
To the petition, it has to assert.
it has to assert grounds. That's
That's
to,
the
yeah.
complete statement of the grounds.
But as John said, do we have someone judging what those grounds are? And are these grounds the same as those grounds? And I just don't want to go there.
That sound like.
You're
Well,
right,
you know,
it's ordinance.
people
When
want
we
to
call somebody, they.
Bill, the tie's gonna go to the runner, so if you look at the face of the two petitions, okay? Because we did X, and then they said, well, it's X in different words. I mean, we can't be in a position to disenfranchise them.
Right, that's why I don't even want to go there.
Unless they're claiming something that is illegal, or they're claiming something that is not proven, or how do you keep people from making false claims?
Your ethics ordinance.
Well, you can't. It's one of the reasons why it might be good to say misconduct, whatever the other two categories are, because then their statement of the grounds is gonna have to reasonably fall within one of those three categories, as opposed to, he believes the moon's made of cheese, and therefore he's not qualified to be a council member.
So I heard a comment coming from the back here that's probably a pretty good point that'll tie, if you make reference to the ethics ordinance, can we do that?
Yes, you can, but that can always change.
Every 2 years.
So some charters, for recall, the petition presented to that council member, and don't have a chance to answer.
That was your answer. It doesn't mean it's proper.
Some charters say they call a public hearing and let the effective council member respond to it, but once the petition is submitted, it doesn't make any difference what that
Yeah.
person has to say or not.
Yeah, I'm just saying, if it
Procedural.
falls, you know.
Yeah, it's a fait accompli if the petition is sufficient.
Well,
So I'm not advocating anything, okay? I'm just saying, one good reason to have, you know, malfeasance, misconduct, at least that when the stated grounds are gonna have to reasonably fall within one of those three categories.
I think the 10% is your checks and balance right there. If you can get 6,000 plus signatures, you know it's a valid reason to be yes. But surely 6,000 petition signers wouldn't be in the dark.
Richardson voters are pretty sharp, so they're gonna figure out what's right and wrong. So in this city, I don't think we have to worry.
And to follow up my comment, if you said, you know, misconduct or malfeasance, then really what you're saying is you can only recall a council member for cause, even though they may want to recall them because they don't like the way they voted on something. It wasn't malfeasance, it wasn't misconduct. I don't like the way you voted on the Palisades zoning case, for example. And maybe enough people say, oh, I want to recall because of the Palisades zoning case.
Objected to that.
675.
I'm not suggesting that either. Just use that as an example.
Gerald?
Is there a requirement in the petition that the grounds be stated?
Yeah.
There is? Where's that? Is that in this, or is it on the
It's
petition?
in,
Hey,
A, yeah.
A?
Which petitions shall
Complete
name the
statement
mayor
of the
and
grounds
member
for
of
which.
Okay, complete statement of the grounds.
Right.
Whatever those grounds
Well, I
are.
think that
That pretty well
that covers it. If it's stated and says filed upon new and different grounds, but not upon the same ground.
And we would never be able to definitively list all of the
Everything
things
they want.
that somebody could do while in office.
It could
that
be the
might
moon is made of
lead-
cheese one time, or it's made of oranges the next time, right? Is that it?
And Erica and John make a good point, that first of all, you've got to get the requisite numbers
Right.
there. And then second, you've just got to trust the voters. And, you know, we're talking about hypotheticals here, but I've never encountered a recall election as long as I've lived here, so for the most part, people suss it out.
I will note that if we accept the language that Pete pointed out at the bottom of the page, only one recall petition per term, then we don't need to say anything about new petition on new and different grounds, because you can't do a second recall.
Well,
on
but
the
you're
same
allowing them to amend
File
it.
another,
petition.
go through, if that was ruled invalid, and if you
No.
go through.
Look at the alternative language at the bottom. No recall petition shall be filed, I assume is what that meant, against the mayor or any council member within 6 months after the election filed, and the mayor and council member shall not be subject to more than
Oh, I
one
see what you're
recall election. It doesn't say one recall election on specific grounds, it just says recall election, period. So once the first petition's failed and the amendment period is passed, you
That's it.
can't do it again that
Make
time,
it count.
if we accept that alternative language. So that makes that paragraph up at F simpler, because once the amendment period passes and they didn't satisfy, it's over.
It's a material
Well-
change and not a state.
Is that not true?
Statute regulation.
Arguably, yes, but I think it's better to make it clear that if you're gonna limit how many recall petitions can be filed, a time period when they can file it, you gotta go ahead and clearly state that. So, you know, depending what your discussion is on the 504 add-on stuff, I suggested. I mean,
Well, if we allow more than one term, then yes, some language needs to be cleaned, I agree. And I think more than one term is acceptable if it's not.
So in F, I didn't change the substantive language, okay? So I didn't change that substantive part. And so, and I threw out for your consideration 5.04, the recall limitation. So depending what you do there may affect what you want to do on that last part.
Materially changing and not a state.
It would be my preference at the end of full F, that instead of saying maybe filed anew on different grounds, it would be my preference to say we couldn't do a new one for 90 days or 180 days or something like that. And that way, we don't have anyone trying to judge if it's new on different grounds or the old grounds repackaged or, you know, again, who's gonna make that decision? If the council makes it, then the person will just go to court, you know, why do that? We're giving the public the ability to recall people for no particular reason, which I think is okay. Because actually voting on a zoning case, in fact, I think is a valid reason. So I would just say, for that last sentence, just say, shall not be amended further, and no new petition shall be filed for at least 90 or 180 days, recall petition.
You want to hold that thought until you discuss the 5.04?
I was only trying to help the chairman by actually getting a paragraph approved. But if we can't do it yet, that's fine.
Well,
I mean, because you're right, the two of them do work
right.
together.
So, Chairman, you know, maybe we ought to talk about 504 if you want to limit a time period by which it can be submitted or how often. And see if you have any interest in that so that we can address F and 504.
That's fine. And we put F in advance until we finish 504.
I think that would be appropriate based on the discussion we've had, that we take F and we'll hold tight on that. Okay, let's move to G then. Could we say, I'll throw this out, it says, if the petition is found to be sufficient, could we say if the petition is accepted?
No,
They don't accept it.
no.
Well,
She looks at it and then she determines it's sufficient and then she slaps certificate on mighty fine petition. And then she submits it to the council, so there's no exception.
okay.
She's just certifying it's sufficient, has a written signature.
In your example, though, if it was a petition to recall someone who wasn't on the council, is that reason to find it not sufficient?
I would think so.
Well,
I
that's
don't
within
think
the
anybody
authority
could
of the-
argue with that.
Well, I'm just curious if that's within the scope of the authority of the city secretary.
I would think so.
So content does matter a little bit.
Bill, there's no way to address all the what ifs, so I would say yes.
You mean if someone resigned and politician? For example?
Well, as G says, if the petition gets submitted and the council member decides to resign, the council doesn't have to call an election. So if they resign even before the petition's filed, I'm sure it'd be the same thing.
Then it's a new point.
Yeah, it's a moot point, but.
So-
And that makes sense.
That beating that dead horse sufficient. be inserted 5 days or next regular council meeting, so that we don't have to have a special call meeting. And added provision notify the affected person, obviously, that would happen, but it would be nice to formally notify. And then the rest was to conform to the election laws.
Let me ask you,
Yes, sir.
does the council, when this petition is submitted to them, have the right and/or the obligation to determine if it's frivolous or not, or do they not have any choice?
They don't have any choice.
I would think it's like the charter language in the
It's-
state law, you
You
don't
know,
have a choice.
if it meets all the requirements, they don't have any discretion. They're supposed to call the election. If they don't, then someone can go to district court and file suit.
Which is the appeal section, which is down there.
Right.
But I just, I guess you would have to say that anything that comes up and is presented to the city council and is sufficient,
Right.
proper number of signatures and all that, it goes on an election,
Yes.
Unless the person resigns.
unless the person resigns. Okay, that's pretty clear.
Yeah, I think that looks good. So I'm happy with you the way it is.
All right. Any thoughts on H?
There's no change on
No
it.
changes recommended. Kim?
I have a question. Under, this says if the mayor or council member in question resigns, no election shall be necessary. I question that because it's said in statute how you can replace a school board member, and I just wondered if it was said in statute about how you replace a city council member. If it was in, if their resignation falls inside 180 days till the next election,
School-
it's one set of.
Schools have different.
Okay,
set
I
of
didn't know
rules.
if that was an election code thing or if that was a school board trustee
It
election code.
may be, but it's unique to school, and I don't know whether it's an election code or in the Constitution.
Okay.
But we just have 2-year terms, so we can appoint someone or have an election, and we'll talk about that in a later session.
Okay.
But-
You can for school board too, but it depends on how soon it is to the
Right,
next election.
the next election.
Correct. It's in Article 3 of the charter. We indicate how we fill vacancies.
And if we had 3-year terms like a lot of cities do, there's a similar rule, but the legislature in the last session changed the law and said that the city could appoint someone if they wanted to. So they either got to call special election or appoint somebody, whereas in the past for cities that had 3-year terms, it was in that magical time period, they had to call an election, which got to be pretty expensive. And people would wait to resign so as not to trigger elections that cause cost to the city.
Okay, could we maybe get someone that would like to make a motion to accept 5.02? Wait,
Yeah.
well, I was gonna say excluding F.
No, we need to talk about 504, and then we,
503 or 504?
let's talk about 504, and then we can go back and,
Do 503.
Okay, I was gonna just say excluding F, and then we add, come back to F and 503.
No, I think we can hammer it out here.
Okay,
quickly,
let's do it.
put them all
Okay.
together.
All right, we're gonna do 503, then 504, or you going straight to 504? What's your recommendation?
was there any, do we have any comments or changes on 503?
That's
No.
pretty good.
Dallas County.
And Holland.
We changed it in other places.
Yeah, I thought about that. You know,
I think you changed it into a county court, or a district judge of a county, or you changed it to be a bit more generic. You didn't specify Dallas County.
Bill, I was trying not to change every single
Well,
line of this
I know,
article.
but it just looks like something that's ignored the fact that a third of our cities in Collins County.
Well, but that doesn't mean that you change your judicial direction. If you want to file suit, the city can decide that that's what they want to do, is file in that court.
City Hall's in Dallas County.
Well, I suppose so.
So
It
that's
just
at the
is a
prerogative of the
puzzling
council.
thing.
And if you want.
Not if it's in here.
Well, that's what I'm saying. It is in here as Dallas County, so I guess, you know, this stops somebody from venue shopping, basically.
So
would be interesting if the majority of your petition signers are in Collin County.
Well, when this was written, probably most everybody
Well, I'm sure that
in
was,
Collin
everyone was in Dallas County.
Gerald?
Pete, when the city sued, are they sued in Dallas or Collin County or just Dallas?
Sometimes Collin County. Actually, I prefer to be sued in Collin County. But-
So it can't be
But
either.
in our contracts, and we put
Say-
Dallas County
say
as an
jurisdiction.
exclusive venue. We always try to do Dallas County.
I would say be consistent with that.
So, I mean, that's, I can go back and double check that, but like I say, Bill, it works. And I don't, if they filed in Collin County, I can go back and check and see whether it absolutely has to be filed in Dallas County, but I don't think it does.
We fall back on your do no harm.
Yeah.
But it would seem that there's a very small sliver of,
Careful, because I live in Collin County.
I know, it's a small sliver.
It's an important
The
sliver.
majority, yes, there is, it is an important
Don't
sliver.
like full sliver.
Yeah, it seems like for ease of operation and to be consistent with what we've been doing over time, I will leave that as it is and not try to be all this.
Because I think what we'd be faced with is arguing to the Collin County District Judge, well, no, exclusive venues in Dallas County, because well, you're situated in both counties, so I don't know the answer to the question. I'm saying it's not broken, it works,
Do no harm?
do no harm.
So you're saying if a judge in Collin County ordered the city to have an election, we do it? Right?
Bill, I'm not answering that question right now, because I don't know what we would do.
Oh, so that would be a council decision, not a city attorney decision?
Well,
Well, I'm just saying, I mean, that's basically.
A lot can change between this moment and when that happens. There may be different laws, there may be,
Too many words.
it's just, I'm saying it doesn't do any harm, so let's leave it as is if you want. If you want to change it, we can, and I'll go and double check it, see whether we should put in Dallas or Collin County, or,
I'm going to vote for keeping it the way it is because of the fact of the can of worms that it opens up a lot of other ways to do business.
Yeah, I like the consistency.
But we
If our
already
contracts
changed it
are
earlier
based
in this
in Dallas County,
commission.
then let's just keep it consistent.
John raised the possibility of form shopping,
Yeah.
which is,
I guess what bothers me is not a legal issue, but a political issue of trying to ensure that some people in the city don't feel disenfranchised by the statutes of the city. I mean, we go out of our way to avoid no bad feelings of east versus west, even though some people try to trump up the east and west, and blah, blah. And, to me, this is just an opportunity for someone to say, see, Collin County, they don't care about you. Which is not true, but they're gonna wonder, you take the average citizen who doesn't have the background, they're gonna wonder, why only Dallas County? And I can't answer the question, both I'm not an average citizen, I don't know, why does it say Dallas County?
The predominant portion of the city is in Dallas County.
Yeah, but a third of the land and a fourth of the voters are in Collin County. Our city attorney's in Collin County, apparently.
Do you feel this information?
not at all.
Well,
Only when you talk like
That's my concern here, is that I just don't want to give people the opportunity to say, see, the powers that be, they don't like the east side, or they don't like Collin County, or they don't like, because it's
Bill?
embodied in their language.
I might, if I can say, be so bold as to say, you're beating a dead horse. I mean, I will go back and check to see whether there's any reason why we should include Collin County. But I don't, I hear what you're saying, but I'm a resident of Collin County, and I have been since 1981, and I don't feel disenfranchised because of,
I would tell you it's just consistent with how many of our legal agreements and contracts are structured now.
right.
That
Yes.
makes-
It's
City Hall
different.
is in Dallas.
And if you in a contract, you negotiate with the person, you propose
No,
that the court's going to
that's
Dallas
not-
County.
Yeah.
Gerald,
They have to agree to it, or they don't.
Gerald, tell them about exclusive venue. Cities have, they have the right to be sued in the county in which they're situated.
That's right.
Right.
They pick and choose.
It's a choice.
When he brings up contracts, I've certainly signed a lot of contracts, and basically you put in the venue you want to be sued in, and they count.
Well, even if it's not a, even if it's not a contract, even if it's not a contract, it's a
Lease.
fender bender,
Mhm.
we're still entitled to be sued in the county in which the city is situated.
But remember also the circumstances of this section too, because you've got a city council in this case, in this scenario, they're openly defying the city charter. They're refusing to order an election that is set out at that point. So it should not be a problem finding a judge anywhere who's going to be willing to order the election.
Which is the point of fighting.
I look forward, Pete, to you researching this. I will just.
I look forward to researching it for you.
I will just call to mind, we actually did change similar language in one of our earlier meetings.
I know.
I don't remember what it was, but we
I'm gonna
did.
go back and spank myself.
Just don't ask me to do it.
Shit.
Okay, so I apologize, Mr. Chairman. I apparently am okay with 503 pending Pete's research.
All right,
That pie's getting really old.
let's move on to 5.04, and we'll relate that back to F as needed, okay?
Are we filling petitions or are we filing petitions?
Little typo.
Count-wise, mayor and lawyer.
Well, that's one of those that we're gonna decide on later.
I think the.
Thank you.
I think the alternative language here is better.
Amy,
Absolutely.
well, I know.
But one thought, if Richardson ever has other than 2-year council terms, they might want to allow more than one recall.
That was just an example, so I mean,
Why don't we note that for a possible change if council terms should change as
Sure.
a result of our efforts?
You will have the opportunity to go back
Sure.
at the end of the process
So,
if you need to true something up.
I'm not in favor actually of saying you got one shot at the well for the duration of the term. I just don't want it to be very often, so if I put on 180-day.
you only have a 2-year term.
I know, but, I can say, okay, if the position fails, you have to wait 6 months before submitting the next one. There's not a big window there because you're already saying not in the first 6 months and not in the last 3 months. I feel like it's a bit intimidating to people. Okay, if I survive, if that creep survives one petition, then he's good for the rest of the term, as opposed to, as Jason might point out, more things come out in the 3 or 6 months, and it turns out people maybe really did want to recall him, and now they can't because they're prohibited from doing another recall petition.
I think in all likelihood, it's more likely that if you have to go back to the well, you have to file another petition, you're probably gonna have fewer signatures every time
Yes,
you go there.
right.
But if you've got Caligula,
Right.
as your councilman,
I wish we could have removed him, but, and that would address Nancy's issue about if the terms get longer. I hate to set up things we'll have to remember to change if other things change. I'd rather just set it up now. You can't do a recall petition on a member more than, say, once every 6 months or something like that. And you don't pick it, 6 months, a year, whatever, but where we don't have a blanket prohibition against more than one recall attempt.
Bill, don't forget, you got uniform election days, and who knows what the legislature's gonna do this time, because there now is a bill up to, but everybody on November. So, we just remember, they file a petition, we gotta wait for the next uniform election day.
Sure.
That may be May, it may be June, November. So, they may only have 2 or 3 months left on that term.
so logistically, it really could only be once because of
In theory,
state.
in theory.
Yeah, I just don't want
would
to
be all
say
the reason
so.
not to have the language in there. So it would be likely that it would be the next election.
Mhm.
I agree with you. know, and if there's more evidence that comes out about the offending councilman.
You need to have them protected by the charter. Pete, it turns out, since you brought this up, that a recall petition is accepted, but the uniform election date isn't until like after the next term starts or something?
Yeah.
Does that still proceed?
Yes.
Okay. Just add that.
The recall would still proceed?
Yes.
Assuming the person got reelected, of course, right? Actually, if they misses the
So
election.
you could have, you could have a recall election, and you could have an election
All at the same time.
all at the same time.
Yes.
Recall for Johnny, and election, Johnny's running for office again, so.
You could lose and win on the same day, right?
That's
You'd have to wait another
I
6
think that
months.
happens. I think that
What came
happens.
first, the chicken or the egg?
I like the language the way it is in both sections, F and 5.04. I don't like restricting to one time, and I think there are enough restrictions in 5.04 within 6 months, and then after 3 months after the recall election to limit it with 2-year terms. If the terms get longer, then it can be addressed at that point. And I like it the way it is.
Good.
So you like 504, the first one, not the alternate?
I like the first one, yes.
Okay, so what does that do for the last sentence in F? Are you gonna permit another recall attempt?
I
at the
think
same
you, I
term?
think you ended after further amended, so not be further amended, period.
Yeah.
And then let 504 explain the rest.
Yeah.
Sure, I like that.
So they have 10 days to make it right, or that's it?
That's it for the rest of the term.
No.
Okay. Well,
He
for
just
6
deleted.
months, within 6 months.
And they,
File new one.
then,
Well, we're talking about two different things.
We're not talking about the last alternative language,
We're talking about the first.
the first one.
You're talking
Oh, I see
about
what you
F, cutting it off after it shall not be further amended.
I thought that's what you said.
Yes.
I thought that's what you
that's what I said.
So you're right, now what section we're looking at. But the effect of it, I'm not sure. You may be right.
Basically, the end of that was trying to say you couldn't do a vote on the exact same thing. You had to change it to file a new one. And my attitude is, let's don't get into what a new one is. Let's just put a time limit on it, and then we won't have people judging if it's a new one or not. You know, why invite an argument that can't be solved?
Why don't we do, kind of break it up in pieces? Does everyone like the idea that you can't have a recall petition within 6 months after a person is elected?
That's all.
Or within 3 months after the
Well,
election.
let's start with that.
Yes.
Yes.
Okay. And then, then we'll go second part. If they were subject to recall election, do you want to limit that to,
Within 3 months.
so they've been in 6 months, 7th month recall election, they survive that recall election, then they come back 3 months later.
I'm sorry, I was misreading 504. I didn't realize that it puts a 3-month timer between recall
Yes.
attempts.
Yeah, that's why.
I apologize.
That's
to
why it
those.
makes sense.
So they don't survive a recall election, they just survive the attempt to recall. The petition fails for some reason, correct?
Yes, yes, and then there's a 3-month timer before they can try again.
Try again.
Right. Okay, well, that's groovy, I'm sorry I didn't read it that way. I thought it was actually saying, as some cities do, you can't have a recall election, say, less than 3 months before the end of the term.
No, this is like a bumper.
Well, you know, why have a recall election when there's 2 months left in the term? That seems kind of a waste of taxpayer
I
money.
mean, we can address that and say, or within 3 months prior to the expiration of the current term.
If we added that, I think that would be great, because then it puts a timer that says you can't have these petitions involved for another 3 months.
You can do it every 3 months, but in no case,
3 months before the
but no case within 3 months of the end of the term.
Problem is, the election serves the same purpose as a recall election.
That's why you don't want to have it so close to the end of the term. It's a waste of taxpayer money.
Well, I would think the people that would propose it would probably realize the futility of it and just focus on the election itself.
Yes, but why not codify it? Remember, we're trying to make it to where the public has the opportunity to recall people that they have problems with, but not make it so onerous that the taxpayer is having to pay over and over and over again to fund these elections.
I think if it were a problem, it would have happened already, though. That makes sense.
Richardson is a little paradox in the world. Honestly, there are other cities that have lots more problems than we do.
Moving on, Deadworks.
I'm not going to mention cities that begin with I over on the west side of Dallas County.
Well, what happens if they do something really horrid during the first 6 months?
And
Do we
some
assume
cities,
they'll resign?
some cities actually specify 3 months instead of 6 months on the outset, but probably for that reason.
Why are we giving such a buffer?
Right, and that's a fair question. I'd be happy with 3 months.
Now, remember, this is in addition to other actions that can be taken. In other words, somewhere in there, Pete, doesn't the council get the prerogative to do a removal of a fellow council member? So if it's so onerous that it's either very illegal or it's extremely public and embarrassing to the city or violation of charter or whatever, the council can then take action against the offender.
You're right, John. I mean, this means that the person is, officer is totally out of sync with the public.
Correct.
And maybe that can't happen before 6 months.
Or if it bothers people enough that they've elected somebody 6 months ago by mistake and they should have thought differently, this at least gives them an option to take that action, but give the guys or ladies 6 months to see how they do in office.
3 months seems short. To really make that assessment,
Yeah.
it seems short. Because 1 month is just trying to get the petition to be sufficient.
Hell, it'll be 4 months before they speak up in a meeting.
Absolutely, yeah.
So,
So 6 months.
Okay, so what we're saying is 6 months after the election, not within 3 months before the end of term, and not more often, and not within 3 months after an election for the previous recall.
huh?
Correct.
Yeah.
Right.
Correct, but
Yeah,
it sounds
the three
strange.
things.
It sounds strange.
I could do it in Latin.
No, it just,
But it is those 3 concepts that we'd like to include in the 504.
Can I suggest a reordering that may help?
Sure.
Okay, so go with Pete's language, no recall petition shall be filed against the mayor or any council member within 6 months after such person's election, or within 3 months after an election of such person's recall, comma, but in no case within 3 months of their end of their term.
there you go.
That makes sense.
Good.
Will you say that one more time
Sure.
for Amy?
Okay.
Are you reading the alternative language?
No.
No,
The first
the
one.
one above.
The first one.
And you're essentially just gonna add, after the last word recall, add comma, but in no case within 3 months of the end of their term.
Can I suggest a little?
Oh, sure.
different language? In no case within 3 months prior to the expiration of such person's current term of office.
Okay.
And that's slightly different than election by what, 2 weeks, 3 weeks?
2.
Is that meeting? It just, we specify election in the first part of the sentence.
Okay.
So, I like signature.
So we're talking about the first one in 504. No recall petition shall be filed against the mayor or any council member in 6 months after such person's election, or within 3 months after election for such person's recall. and in no case?
But in no case.
But in no case? But in no case within 3 months prior to the expiration of such person's current term of office.
And that way, when we go, if we go to 3 or 4 year terms, we don't have to change it.
Okay, now go back to, now, do we need to do anything?
I think we should just, where the word amended is, we should just put a period and chop off the rest of the paragraph.
Mhm.
We don't need it anymore.
Exactly. Which is what you said earlier.
And help me out, I'm a little slow on this. We don't need it because we don't care whether they file it upon the same grounds.
That's
Is that
right, that's
Yeah.
right.
We have the time limits.
We're gonna be silent on the grounds. It's up to the person doing the petition to provide the statement of grounds. And we're not gonna judge if they're qualified or not.
That's up to the voter.
Yeah, yeah, absolutely.
As long as it's
But it-
sufficient, it's up to the voter.
But Joe raises a good point. Do you, do you want to let someone keep bringing the same recall petition within the time period that works for the same reasons?
And
So they
yes,
go and it doesn't pass, and then they wait 3 months and they bring it again. Voters have already said no one time, and now that person brings back the same petition. And maybe that phrase should be someplace else, maybe it should be in 504, but that's really kind of the question at heart is, do you want them to, does it have to be about some other, could be some other reason, or you're saying it's got to be a different one each time?
I think Jason's point was germane, is that if it failed the first time, what are the odds you're gonna get 10% of the registered voters to sign another petition? You see, it's not finding the, it's actually getting enough signatures, and as you know, you have to get way more than 10% because so many fall out. Well, now we're talking about 7,000 or 8,000, when we, except for the last mayor's race, we seldom had more than 9,000 voting in a municipal election.
But if you look at that, I'm not old enough to know what the framers' intent were, but it appears that they were saying you could amend it one time, but after that, you're done. You could always file a new one, but it's going to be on different grounds. So it looks like the intent was you had
It
one.
prevents harassment.
Yeah, you had one shot at the apple, and then next time it better be a banana.
But what of the concept of, I'm going to paint my banana red to make it look more like an apple? I mean, it's still the same apple. In other words, they're just rewording it, repackaging it, I think, you know.
Well, let's
And who's
take-
gonna judge? I mean, there's no, it can always happen.
Let's say it's a zoning case. I want to remove that person because they voted against the zoning case.
Sure.
And they do a recall, and they get enough signatures, but it fails. So then they can come back 3 months later and bring the same people who signed the petition to bring it back to the voters again. So I mean,
They'll have to get
that's
the
the point you're getting
signatures
to.
Yeah, to counter Jason's point, if you got those people the first time, chances are you will get them the second time.
Because they'll be even more revved up because they weren't successful.
So I think it's a good restriction to prevent harassment. That's my opinion.
They're all hypotheticals at this point. I think they're right. And if they can collect 10,000 signatures,
Man, I guess the point of it is, if you can collect the signatures, then it's okay to do it.
Taxpayers
There
are
must be
saying it's
something-
okay to spend money.
Taxpayers are saying basically,
Yep.
that if they meet the hurdle of the signature level, then it goes forward, and if they fail in the election, then if the signature collectors want to spend their lives doing that, then let them come back and do it. And harassment is a very funny thing. There's all kinds of, harassment out there, and that's just normal part of public life these days. So, I mean, you're never gonna eliminate it, but you don't wanna stymie.
I agree with that.
Well, we don't want to be such a recall more than one time because that looks like it looks.
Sure.
All of a sudden, that alternative language starting to look pretty.
Yeah.
I guess if there's a need for multiple recalls, there's a larger issue on the table. That will likely resolve itself.
That alternative is less subjective, isn't it? It's straight, you get one shot, for whatever reason.
Okay, let's pull this together, gang.
I'll shift.
Yeah.
Can we be honest?
I will propose a motion to approve 5.02 with the alternative language in 5.0. Well,
Is that what you mean?
I guess, yeah, I guess that's what I mean. I will, let's see, hold on a second, are we through section 5?
Yes,
Yes, okay,
yes.
okay. I'll make a motion that we approve section 5 as amended with the inclusion of the alternative language that is in there for 5.04.
Now, we did have some changes in 502A.
Yes.
Are we approving the whole article?
Yes.
Well, you've already approved
I've already
501.
approved 501.
We approved 501, now we want to look at 502,
Separate.
through 504, correct?
Well, I think it'd be 502 A through H.
Okay, A through H, that's a good idea. I'll do-
And just to
Move A through H.
recap, in 502A, in the first line, you're changing, before the question to recall the mayor, you're changing, taking out and put in or a council member. And then adding the mayor on that last line.
Well, we have, on the third line, taking out and or, just putting or, and on the fifth line, taking out and or, putting or. So there's 3 and ors that we're changing to or.
Yes.
Yeah,
Being consistent throughout the paragraph.
I love that.
right.
So in other words, before the question of recall, the mayor or a council member shall be submitted to the qualified voters of the city a petition, city council, city of Richardson, demanding a recall of the mayor or the council member.
Or a council.
Or a council member shall first be filed with the city secretary, which petition shall name the mayor or council member. And then do that.
Right. And then in D, we're changing officer to official.
Correct?
And then we didn't have any changes to G or H other than what we had recommended, but we still need to address that. So,
I think we put a period after amended and cut off the rest of the paragraph.
Well, John has a motion, so he has to accept the amendment.
And as long as it's consistent with the alternative language in 5.04,
so your motion, just so everybody understands what we're voting on, is 502 with the changes we just mentioned in A and in D. And then in F, put in a period after further amended, striking the rest of that language in 502A. G as recommended, H as it is, 503 as it is, and then you're saying you want the alternative language in 5.04, recall limitations.
yes.
Including no more than one recall election.
Include- Yes.
Okay.
The alternative language.
Got it.
Correct. Okay. Do we have a second? Okay, got a second. Laura. Any additional discussion?
I will be voting against this because I don't like the alternative language. I like you, John, I just don't like the alternative language. I think we should, let it open. If the voters want to pay the money and get 6,000 signatures. I don't want to have too many recall elections, but on the other hand, one per term.
Yeah.
Why put that impediment in there?
And I look at it as one per issue. If the voters turn it down once, then they've spoken.
But that's not what this specifies. There could be multiple issues.
Then it's a new thing altogether.
But you took
That
out the
might-
language about the
and that-
grounds.
I was gonna say, there's always the opportunity for, you could pick apart an issue and say, there's this part of it, this part of it, this part of it, and you can just keep going. And that's when the harassment issue comes in. Are they doing it for harassment, or there are legitimate terms to get somebody out of there? And how do the voters feel about that?
The voters don't have to sign the petition.
10% of them do.
Yeah, that's 6,000 of them, which is,
Correct.
some
I agree.
elections, 100% of the people who vote in municipal
And
elections.
sometimes more.
I mean,
I hear what you're saying, but I just, if you can, we gotta come down on one side of this one way or the other.
Here, I'm not gonna come down to your side.
All right, great.
Okay, Gerald.
My comment is just, Councilman Murphy, under the alternative language, the voters get one shot to recall it for whatever reason, just one shot.
That's right.
That's it.
That's what it says.
Okay.
So there are no repercussions for a council member.
That's right.
If
Unless
there's
it's
more
divided,
than one
you can misbehave all at
instance
once.
of misconduct.
Now, wait a minute.
I know, according to the voters, you're saying there are other
Well,
checks and
remember,
balances in place.
we're only talking about a recall. That's all we're talking about.
And not the ethics or anything else.
So let me just say that I'll be voting against it, but only for the reason that I think that F should remain as presented by the city attorney. And 504, I like the restrictions we put on it in the first paragraph. And I think there should be more than one shot because there may be other grounds. But I don't think you should be able to bring the same grounds over and over again.
Okay?
So that's why I like
If there's
F.
a limit on bringing the same grounds, I'll go with that.
Well, under your scenario, you only get one shot.
Well,
So that's it.
take out that part
Okay.
of the scenario.
Okay, hold on. You got a motion, we
Yeah.
have a second, do we want to reword the motion? Can we do that?
What do we go back to which one?
F is the sticky.
Let me suggest this.
Do you want to withdraw the
Maybe
motion?
withdraw your second, withdraw your motion, let's have some more discussion. Unless somebody wants to call the question or vote on the motion.
I think there may be a misunderstanding. I really do. So I'd like your suggestion if they're
Okay.
amenable to it.
I
If they're
will
amenable
recall my
to it, some
second.
more discussion may help.
Sure.
Okay.
I'm recalling my second.
Recall her second.
Yeah, we'll
You
withdraw.
only get
And
one of
John
those.
withdraws
Oh,
his
wait, wait.
motion.
All
Okay.
right. Okay, we're okay, except for F and 504. So if we go back to recap, what Shannon has suggested in 504, the first provision, no recall petition shall be filed against the mayor and council member within 6 months after election, or 3 months after recall, but in no case within 3 months prior to expiration of such person's term of office.
I think that's fine.
And Gerald, you're saying leave F as it is because there may be other grounds for a recall.
Right, I think that's reasonable. I think those two together is a reasonable,
As long as it's totally new,
yes.
reason for a recall.
But John, who makes the judgment that it's different grounds? There's no mechanism described in here.
Well,
Who makes that judgment?
If it says on the top of the petition that the person is being recalled for failure to attend meetings or failure to do something, that failure is pretty consistent, and you wouldn't want, or it's identifiable, and so you wouldn't allow that to be the same
It's
reason.
a different zoning case. So it will technically be on different grounds, even though it really is the same and everyone knows it, just like Marta painting that banana red. I mean, let's don't invent a process that we don't define how we're gonna solve the problem. Who's to say it's the same grounds or not? The council's certainly not gonna decide it. We're gonna invite a court to decide it. That's why I don't even wanna go there. If the public wants to recall somebody, their only explanation owed to anybody of the statement of the grounds is to the public.
Well, that is a good point, and so you're recommending we leave F as is?
No, I'm recommending we drop everything in F after the word amended.
All right,
I could go along with that.
okay.
Yeah, and
I could
then-
go along with that.
That'll work.
I'd rather not, but I think,
We're supposing that a lot of problems are gonna come out of this, but probably not
No,
all.
probably not.
I think there's some other checks in place that
Yeah.
Sure.
might prevent that from happening.
Likelihood is
So-
if you're going after a council member for tough votes, everything's gonna relate back to them. Let's say there are 2 recalls that are placed on it, everything's gonna relate back to the grounds for that first recall anyway.
True.
It's like Marta says, it's the banana painted red.
So if we ended after amended and go back to section 5.04, the amended language that Sharon.
For the first
Shannon
section.
All the
either-
other, language was,
Then I think that's a middle ground for, I think, everybody here so
I
far.
would be okay.
I would too.
Yeah, I think it works, and I think
I
the
would-
restrictions in
that's
504 are enough.
Yeah,
I
that
think
works.
they're enough.
That works.
So is that clear what we're voting on?
Someone make a motion.
John, you wanna make a motion again?
Let me try this again.
Okay.
My twin brother, evil twin brother will be making this one. I make a motion that we approve 504 with the stated changes that be outlined in A through.
Should be 502.
502.
I'm sorry, 502.
And 503 and 504.
No, we're just gonna do 502 right now. And with the amended changes.
Hang on.
Okay, go ahead.
In F, we're striking,
Everything after amended,
Everything after amended.
amended period.
and then 503 as is. Does your motion include 503, John? as
Let's
is?
do it. If that's amenable to everyone, let's do it.
Yes.
And then in 504, you're taking,
It's Shannon's paragraph.
Shannon's paragraph.
can I suggest, instead of the word but, maybe and in no case?
Sure.
Sure.
All right.
That's fine. It's your motion, sir.
Okay, that sounds good.
Okay. We have a motion by John, we have a second by Erica. Any additional discussion? All right, show of hands in favor. Okay, passes unanimous.
It's kind of a group motion. I don't think anyone.
But that's why we're all here, to help each other make
That's
those
right.
motions.
That's right.
Okay.
Right.
Anybody want to take a break or anything, get a piece of pie before we go to Article 14?
Can we throw this?
Yeah, let's
Restrooms
keep
right
going.
out there,
It's almost ready.
right before you get to the
Let's go to
stairs.
the,
Yeah.
A minute.
go ahead.
Got a restroom break, okay. We'll wait, yeah, go ahead. We'll wait till you get back.
I was kind of curious how the votes were gonna play out.
It would have been interesting.
You wanna
I think
see
we were
that
gonna
comment?
split.
I wanted to have like a
Do what?
preliminary vote, just to see.
All right,
It was getting
we will
interesting.
go into recess for 5 minutes. Make that a- All right, thank you.
Now we're talking about other stuff, right?
How was old YouTube there?
That's good. We're ready for the holidays. But let me rephrase that. I'm ready for the holidays. Graduation on
I was
Friday.
gonna say, Erica's last day of school Friday, or?
Yeah, graduation is Friday and Saturday. My school's on Friday. So we'll be done.
I had slightly different numbers for the,
What I did was I took up the Excel spreadsheets that I got from the two counties in 2013 and just looked at the number of rows in the Excel spreadsheet and did an approximation. I mean, so they're approximate. It wasn't too big, was it, in 2013?
no, for 2015, Dallas County portion was 42,947.
That's close. I had 43.
I wouldn't think so.
And then the Collin County portion was 2013 that I had.
Yeah,
17,670, for a total of 65.
We expect Collin County to increase, and you know the Secretary of State periodically, because of the Help America Vote Act, now each state Secretary of State actually helps the counties clean up the list.
I think it's gotta be county, it's gotta be county.
In the past.
It's
Not all of ours.
County on this.
What time is it?
Yeah, wasting money.
Right, it's probably 10% of the voters at any one time.
7:43.
My how time flies when dead horses are being beaten.
It's funny.
Outstanding.
23 cups of sugar.
Big three for you.
Hi.
You didn't even taste it, so you can't be impressed.
You gotta taste his soft
Interesting
top.
that Article 5 involved discussion of spanking.
Why isn't that bringing stuff up?
And bananas.
You know what? You're gonna bring plantains?
I'll be happy to.
I'll bring taco.
Quite okay.
Yeah, Amy, you want to have
Where's your ground?
We're gonna have a potluck.
I promise you that. Those are grounds that are stunted.
Did you want to recall Caligula or his horse? The horse.
Both
And more
that we have
recall.
to.
Yep, that's it.
I'm gonna get pie. Does anyone want pie?
Oh, I already got it.
Pie, pie. Kim, you want some pie?
Allegedly, he
Thank
once
you.
told
Erica?
someone
Yeah, I think
that he
I already
wanted to
have.
see how much he could push the Roman people before they killed him. And that's why he was doing things like making his horse a council. And
Pointed them to the Senate.
he wanted to see how.
I am.
much the Romans
That's why I'm not gonna cut you right. There you go.
Unfortunately, it turned out to be a lie. I assume most of those guys.
Shannon,
Oh, you want to use that one?
does the ordinance call for anything other than compliance with state and federal law?
Make it all except for the front?
The likelihood of Caligula
Such a
thinking
good
about
painter you are.
That's why we're here.
Because I was thinking that was the only thing they were charged with. So all of these other general changes.
Well, they have also have as necessary to clarify each of the existing charters to improve the effectiveness.
Watching the Wisconsin.
I don't know what that means. To condense existing charter sections and improve the effective, so they can go out and change the terms, like this whole section.
I think that would fall more under, I think 2 is really more about to make it more readable, understandable. 3 is the one that's more open. It says to review the charter or any other provisions of the charter as the charter review commission determines necessary.
Okay.
3 is much more open-ended. 2 is really to improve the understandability.
Because the whole first few meetings were, we're not materially changing, and all of a sudden we're materially changing, you're materially changing in this section. Well, you changed in 2, too.
You know, I'm gonna try a piece of my pie.
I might.
I mean, it's really good.
I didn't know you were a pie maker.
I'm not, that's the only one I make. It's just, well, I make meat pies.
Your mama didn't teach you to make anything other than chess, huh?
She didn't teach me that. I learned that my own.
No, we were just talking about the ordinance and what the charge was. I was really, there's 3 provisions. 1 is state law, or state and federal law. 2 is really clarification. And then 3 is really whatever they deem necessary.
So they got discretion.
So,
They got full discretion for all.
Yeah, they do, but I'm trying to keep them listed. You know, don't want to have, 99 propositions on there. Language is adequate.
You got a bunch, huh?
it'll happen.
I know.
I was gonna say, I've been in a few.
Where do you determine a rewrite to an amendment?
Well, but some of the propositions will be able to
Come
say-
together.
Come together, because you can put like subject matter in the same proposition.
I was not popular among my friends.
But we got to make sure that we do that. We got to make sure if the one fails, it doesn't screw up the rest of it. So.
Okay.
All right, I think everybody's back. We can reconvene.
Email the recipe to everybody.
Just make it for us. Again.
I'll email it to Amy and she can send it.
Thank you.
All right,
TV.
we'll start discussing Article 14, initiative and referendum. Section 1401, thoughts?
Everyone able to understand the comments in there? There's a difference between initiative and referendum.
I described it previous.
So 1401 pretty much parallels what we said in Article 5, right? In terms of the process.
Yeah, and in some charters, whichever one they do first, then when they come to referendum, let's say they have recall first and they have referendum initiative, they say follow the same process, same signatures as it is. And I was just, like I said, I was trying to make as few changes as possible.
But you simplified it.
Okay. But we didn't change any of the substitute issues, thresholds, any of that.
Mr. Chair, I'm gonna just, and I'll make a confession, I probably messed this up on the SAT by using that too many times, but it appears that that would be appropriate after the word propose in the second line, because it reads may propose any ordinance be submitted to the qualified voters. Maybe propose that any ordinance be submitted to the qualified voters. I don't know, but like I said, probably.
Which line are you looking at, Joe?
The second line, it says the people of the city of Richardson reserve the power to direct legislation by
Propose, oh.
initiative, and in the exercise of such power may propose any ordinance, and those others, I think then it goes down to be submitted. Propose any ordinance be submitted. It just sounds better to me that it reads any, may propose that any ordinance be submitted to the qualified voters. But read it.
No.
You people who are smarter than I am can tell me whether that's an appropriate use of that.
So we have a motion to approve all of Article 14 with that change? That's a joke.
Gerald, let me ask you, are you saying, it says the people, the city of Richardson reserve the power to direct legislation by initiative. In the exercise of such power may propose any ordinance.
He's saying propose that.
Any ordinance.
John?
Yeah, but it's except ordinance, or excuse me, it's any ordinance except those not legally authorized.
That's all fine.
That's all fine, okay.
He just wants to put a that between
It's a
propose and any.
subordinate clause, and he wants to begin with the conjunction that.
Okay.
Is that why I got points taken off on the SAT?
Well, right, I mean, and
Probably so.
in
I'm not
speech,
sure how you
we
got
often
that.
drop to that, but he's right, in written language, you're known to have it
I knew you'd know the answer.
in Latin.
Okay,
Latin,
propose
that's what I
that.
tell you. Does that make sense?
Yep.
Any other changes or comments on 1401?
All right. Go to 1402 then.
You want to vote on that one?
Are we voting or? Yeah, I guess we can. We can. We can.
I'll move for approval with that, move that we recommend approval of 1401 with that added.
That's to me that.
All right. Got a motion, got a second?
I'll second.
Got a second. All right. Any discussion? All right, all in favor? Passage unanimous. Thank you. All right, 1402.
Before we leave 1402, I had that comment in there about limiting and having a time limit or prohibit frequency.
What are you talking about, Pete?
Within 2 years after the date of special election?
This goes back to the grounds.
Same-
This is-
Same
sorry,
like,
I
same like
Yeah, that's a
brief.
grounds.
I haven't seen that yet. That's okay. So it's not mentioned later on about
I don't think
initiative on the same grounds?
He has proposed no ordinance on the same subject matter as initiated ordinance.
Well, but that has the same problem. What's the same subject matter? Who's gonna judge?
Well,
I don't
first of all,
really
just let me correct you. I haven't recommended that. That was just a
Well,
question I was posing to you
right,
because some
right.
charters have a limitation.
Suggestion. Suggestion is even I'm just gonna say.
Bill, everything in life is subjective,
And
except death. Either you're dead or you're not. So, anyway, I just want to make sure you saw the comment in there in case you had any
thank
interest.
you, Gerald pointed it out to me. I had seen it before, and I thought we were reading the paragraphs, so thank you for pointing it out. I would have to say, who's the judge if it's on the same grounds or not, or on the same subject? And it's not that I don't understand the desire to avoid repetitive things in the same subject, but we don't have a mechanism on who's gonna decide it's the same subject.
We do in this one. City
Yeah, it's
attorney.
the attorney. It's the third to the last sentence. Shall review the petition to determine that it is proper subject and in proper form.
That's doesn't mean it's not the same subject.
Well,
The proper subject and proper form, please correct me if I'm wrong, but I believe that's a specific
I
term
mean, you
used
could say-
in the law.
You can say substantially the same subject, because you're right. The ordinance could be, you could have ordinance with A, B, and C, and then they come back with ordinance with
X, Y, Z.
A and B, but no C.
Right.
The voters already rejected A, B, and C. Now they're getting a chance to consider A and B. It's totally your call.
And it might pass. A and B only might pass. I mean, I just prefer not to have subjective judgments. So, Marta, to my subject, the proper subject, proper form, that means it's a proper subject to be an ordinance, and it's physically laid out in the proper language, and has nothing really to do with the content, judging the content.
But it could, that's all I'm saying.
But I don't.
Forget about the subjectiveness of it. The question really is do you want the city to be faced with an initiative on the same ordinance over and over?
Well, but you're saying that you're gonna have 60% of the likely voters authorizing that election, so isn't it their decision?
It's a rhetorical question.
No, it's a philosophical question, as you pointed out earlier. This
But we,
is
you know,
a
in
philosophy question.
Gerald, I forget who else is on the CPC, but you have in the zoning ordinance a prohibition of filing the same or substantially the same zoning ordinance if it's denied with prejudice.
Yes, but don't we
Right.
have a mechanism for deciding?
Well,
Someone
the
decides
city
that.
attorney decides.
Well,
And I think if we're gonna be subjected to legal action, then the city attorney is the appropriate person to review that, to determine that exposure, make that
I mean,
determination.
you could have an ordinance with A, B, and C and take out one. So it's not substantially the same because it's missing C. But you could have A, B, and C, reword A, B, and C, those different words, but it's substantially the same. So it's just a matter of policy, whether or not. We haven't had one in there. It's just not an uncommon provision, so.
No, I understand it, I just don't want to invent things where we don't have a process to accommodate it, and we are all reasonably sure that the 10% threshold and the fact that it costs money to do these elections, Jason said it earlier, you know, if it fails the first time, what are the odds you're going to even get half that many signatures? I mean, just in practice, you know, if the people really want to sign it again and pay for the election, then fine, let them.
All I'm trying to do is bring out ideas
I
and
understand.
concepts.
Thank you for that.
What about the next comment about saying you gotta file it all at one time? Is that of interest to you? All petition papers comprising initiative petitions shall be assembled and filed with the city secretary as one instrument on the same day.
I like that. Basically, what that does is it helps Amy go through that, and it's a difficult job.
It's typically what happens, but that avoids coming in piecemeal, about here's some more, here's some more.
I support it.
I didn't know we allowed that. Can people bring in more names within the 10-day period?
It doesn't clearly,
Technically, they could, because it's not clearly addressed.
it doesn't clearly say that, but, and that's why, you know, if that's the practice or the policy or that desire, let's go ahead and clarify it.
Well, otherwise, the 30 days to submit it, to file it, doesn't mean anything, because it really now drags out to almost 40 days.
And it's an easier task if they just bring it all
Yeah,
at one time.
I agree, I have no problem with that.
Okay. So, Mr. Chairman, I forget whether we approved 1401 as recommended or not.
We approved 1401 with that,
With that.
and now we're discussing 1402.
But do you want to add to 1401 that all petition papers comprising initiative petitions shall be assembled and filed with the city secretary as one instrument on the same day?
Oh, is that where it goes?
Oh, I thought it was going in 1402.
I'm looking at,
P18.
I think it would belong in 1401. The last one talks about the signer making.
Signer, yes,
Yeah.
the papers, yes.
Yes.
It does go in 14.
Okay, with that having been said, if we want to add that, and I think that's the consensus, everybody would like to add that to 1401, we need to withdraw or, no?
Just make another
Amended.
motion.
Just make an amendment?
So I'll
Okay.
make a motion to add to 1401 the statement, all petition papers comprising an initiative petition shall be assembled and filed with the city secretary as one instrument on the same day.
I'll second that.
And you're putting that at the end of the paragraph?
End of the paragraph of 1401.
Okay. We got a motion and a second. Any discussion? Okay, all in favor? Okay, passes unanimously.
That's the amend clause.
There you go. Okay. 1402. Moving on.
Amy didn't suggest that. It's a lot of
I know,
charters.
I know.
I just.
Well, it makes sense that you do it.
Yes, sure. I don't want to assume you already did.
And it doesn't disenfranchise, just doesn't disenfranchise anybody, it doesn't discourage it.
10 days is not that much time to review.
It's the same time, she's performing the same function she did on the recall that you gave her 10 days.
Big time.
She's looking at the,
Examine signatures.
Now, you notice this one cut off the words after amended, and then explicitly says a new petition may be filed to the same effect. So this explicitly says you can file a new initiative on the same subject. I just figure whatever we're doing will have to be probably the same process for all of it. Do we actually specify how often this will get done? Any place?
what do you mean there?
No, that doesn't make sense, because obviously you can have many initiatives on totally different ordinances independent of each other. No, never mind, it just says, basically, after the 10 days of the amendment period, if it fails, that's over, and people have to go back to square one if they want to do the initiative petition again, without any time restraint. And that would prevent the city saying, oh, no, Nancy, you already did a petition, you can't do it anymore.
And I didn't change the substantive language
No,
there.
I'm saying that's okay.
Now, I think what the intent was is you want to keep amending it, you know, you can amend it, you can't make it happen.
Right.
Fine, you can start all over again.
Right, that's fine.
So it's different than the recall. Because you put some limitations on recall.
Not gonna track me that easily, Mr. Smith.
Okay, are we good with 1402?
Yeah, I'll move that we approve 1402 as, what's the language, as proposed by the city attorney.
Second.
Got a second by Gerald. Any further discussion? All in favor, show of hands. Passes unanimously. Brings us to 1403, city council action.
You need a comma after sufficient.
Yes.
Pete, let me ask you a question. Part A there, council's alternative one, I guess. Pass said proposed ordinance without alteration within 20 days. Is that allow for the schedule, council's schedule to actually pass, and it has to be, you vote on it one night, that doesn't make it official until a period of time later. Does 20 days allow for that whole process to take place?
Yes, it does, because there's no necessity to have,
So it's a one-time vote, it's a vote and that's it.
Right.
Okay.
There's
It's
no,
not-
no necessity to have it on the agenda and discuss it. I mean, you can do that, but I'm just saying, there's no multiple readings required.
Okay.
And I know that the tradition here is work session, action meeting, work session, action meeting.
Right.
But a work session is still a meeting, and you can take action at the work session,
Okay.
what you call your work session.
Good, okay, that's good.
The 10% was deleted, does it reappear someplace else?
No, because it's not necessary to repeat it, because it talks about what's required in 1401.
Oh, is that where it is? Okay, yes, thank you, okay.
Because we're, in 1403, we're talking about initiative.
Yep.
And then B is just the special, call the special election.
You have two choices.
Yeah,
You
one or
can either
two.
ratify it as proposed or call special election.
Exactly.
It's not consistent.
All right.
I'll make a motion to accept 1403 with the addition of the comma, A and B as proposed by city attorney.
Okay, Jason seconds. Discussion?
Uh,
John?
I'm
Let
sorry.
me, the last time we received one of these petitions within the city, there were some issues because of conflicts that it created within the charter, which probably is one of the reasons why we're here tonight. But is there any way that we could put a clause in here to say and change those provisions affected by this initiative? Or is that trying to be too proactive in dealing with it?
I'm not sure if like, some topics are not the proper subject of initiative, such as zoning.
True.
Zoning requires a public hearing.
Exactly.
And there's state law on that.
Yes.
Although you can have a referendum or initiative to repeal all zoning or to adopt zoning if you didn't have
Right.
zoning.
If there were a referendum or, an initiative proposed through petition, that we have direct election of the mayor. And that was the case. And therefore, that was voted on by the public and solved. But there are there's downhill issues that create, as their way to put in their wording that says, I guess you couldn't do that because you can't be that proactive, you don't know what's coming forward. Okay.
I guess your comment is, what if someone proposed an ordinance which is contrary to the city charter, and the city charter, let's say, the ordinance is that council members be elected for 3-year terms, and the charter says 2-year terms. Well, I think I would end up with having to report to the council, this is not it's not legal because your charter prohibits it. And we would probably get to the petitioner and say, look, what you need to do instead of this is propose an amendment to the city charter, because that's where the terms are set, not by ordinance. May not be a good example, but
It's a great example, I think, because basically, there's no way you can proactively say what it's going to impact, but you can say in here that unless it's prohibited by charter.
and we deal with that in 501, 1401.
Did I miss that part of it? I'm sorry.
No,
I
you're
did.
talking about a slightly different thing. You're talking about, can the council take this initiative and modify it slightly for whatever reason?
No, they can't.
They can't.
No, but that's what John's talking
No,
about.
what I'm saying is, if they can't, then how do they deal with things that are in conflict with the current charter?
Well, I think he would say, I'm sorry, this isn't the proper form.
And we'd have to go.
Well, that, or if it's submitted, Pete would make recommendations to the council, basically say that this is going to raise.
He has to certify to the council it's a proper subject, i.e. it's an ordinance for the city in its proper form. And I don't think he can do that if it's a blatant violation of the charter.
And then it becomes a council issue, it's not a charter issue. The council has to take the action to say, under
In
policy advisory, we
the
can't do that.
example I gave, they have an ordinance saying council member terms are 3 years. Our charter is 2 years. And so I'd be called upon to say it's not a proper subject of initiative because our charter sets for 2-year terms. And we're a home rule charter, and an ordinance can't modify the charter. So therefore, you can't have an election to determine this because it's not the proper subject.
And otherwise, the council shouldn't be allowed to change it, because that's the whole point of an initiative. The people, in essence, are bypassing the council. And that's fine.
All right, correct me if I'm wrong, we, on 1403, we have a motion and a second. Any further discussion? Okay, all in favor to accept as stated? Show of hands. Opposed? All right, passes unanimously.
I saw a hand go down late.
All right, was it,
Just wanna make sure.
were there any opposed?
Okay.
Okay, passes unanimously. Okay, section 1404.
Chairman, I would we accept the language in section 1404 is submitted.
A second.
All right, got a motion with Jason, second. Okay, any discussion? All in favor, show of hands, please. Passes unanimously. Okay, 1405.
Pete, does your comment 20 refer it, isn't it most ordinances take effect 30 days after the voting on? Where did I see that?
No,
Or is it normal
they
ordinances?
become effective